today's presentation is going to be, and with the catchy title, No Soup for You, but when disinheriting a loved one is necessary. Not trying to make light of it. It's just that the reality is that Seinfeld takes a huge place in our society, and everybody seems to remember that phrase. So I wanted it to be something catchy and share what we're going to be talking about today. All right. So again, any questions, just put them in the box and I'll deal with them in a little bit. When disinheriting a loved one is necessary. Now, the bottom line is that what we're talking about is an estate plan, okay? That we're going to start with the idea of an estate plan and the reality that all inheritances, because we're talking about disinheritances, has to do with planning your estate. So let's start with the definition of what an estate plan is first. It is primarily dealing with inheritances. What are you leaving to the people, to your loved ones, to your beneficiaries after you pass away? It deals with planning for incapacity. It deals with taxation, whether it's estate taxes, capital gains taxes, gift taxes. An estate plan incorporates all of those types of, at least should and could incorporate all that type of taxation issues. It incorporates asset protection, which is the idea of how do I protect my house? How do I protect my income? Can be protection from various sources. It can be creditors in general. It can be the IRS, taxation issues. It can be long-term care and Medicaid. So the idea of an estate plan can sometimes, depending on age and health issues, include planning for long-term care. We're not talking about all that today. Our primary concern is going to be, where will my assets go when I die? Who's going to inherit from me? Who are my beneficiaries? How do they inherit? When do they inherit? Okay, under what circumstances and how? Now, there are different ways that a beneficiary can inherit from us. We talk about this with every client we talk with, every client we meet with. There's different ways that people can receive from you. The first way is through your last will and testament. And that last will and testament is a document that really means nothing until it goes through the probate process. A whole separate webinar, and I have this on the website, tullyelderlaw.com, and we can do it again during the course of this year, is that probate is a court proceeding, sometimes necessary, but something you should try to avoid, all right? Probate is a 6, 7, 8-month process at least. There are court filing fees, there are legal fees, there are privacy issues, there are delays due to pandemics, et cetera. So probate in and of itself is something that should be avoided. However, if you are leaving assets to your beneficiaries through your will, then it will have to go through probate, okay? In addition, you can leave assets for your loved ones and your beneficiaries in a trust. There are revocable trusts, there are irrevocable trusts. Definitely a better strategy, a better method than through a last will and testament. And again, there's more on this on our website and other webinars. And of course, we could always talk more if you have questions. Now, the third way that somebody can inherit from you is from the title of the asset, a joint title, if it's survivorship. So for example, a checking account between spouses or parent and child. It can be a joint account with survivorship. Real estate owned by spouses, it's survivorship. And what that means is the moment the first person, the first joint owner passes, the other one inherits automatically, okay? Avoiding probate, but it's inherited and now they have the asset in hand. The fourth way that we can have our loved ones and beneficiaries inherit is through a beneficiary form, okay? So you can name a beneficiary on your life insurance, on an IRA, on an annuity. That beneficiary form is a contract. The person, the owner, the insured passes away. The beneficiary knows that. They fill out the claim form with the financial company. They get the asset, all right? Now, it's important to note that joint title, survivorship, and beneficiary, that's outright. They're getting that automatically. It does not matter what's going on in that beneficiary's life. It could be good, it could be bad. They are going to inherit from you. At least the will and the trust can have different language forming how the inheritance can be received. either outright as well, which is sometimes a mistake, or in further trust so that it's sheltered and protected. And we'll get into that a bit as we get going here. So this is how people can inherit from us. As I was starting to allude to, the reality is that beneficiaries can have issues. I'm going to give you a list of potential issues that may apply to somebody in your family. It can be a spouse, it can be a child, it can be a grandchild. Okay. So as we're going through this list, think of the different family members or the different beneficiaries you have and take a mental note of which one of these issues and scenarios may apply to you. And we'll talk about it a little bit more as we progress. But first, a sip of coffee, excuse me. So what do we see in our practice every day? We see beneficiaries that are potentially under 25 years of age. That can be a concern as far as inheritances and spending and wisdom and being an adult so that they can actually receive the inheritance. So age and under a certain age certainly plays a big role. We've seen wills where all beneficiaries inherit at 18. We've seen them where all beneficiaries inherit at 21. As a default, as a starting point, we like to pick 25 years of age. And the example I very honestly give is I remember what I was doing at 18, 19, 20, and 21, and perhaps I wouldn't have made the best decision if I inherited a large sum of money. So put yourself in those shoes and realize maybe an older age is more important. And we'll get into how we can do that. So a young age certainly plays a role when it comes to inheritances, as does the opposite side of the spectrum. If you have a beneficiary that is over perhaps 65 years of age, just as a general age, could be 70, 75 years of age, there could be certain potential issues in the future that they are closer to, such as needing help, such as passing away themselves, tax issues, long-term care issues. So again, if there's a beneficiary that is on the older side, again, something to consider when it comes to your estate planning. Another eventuality is poor health. And if you're naming a beneficiary that is where age isn't an issue, but they have concerns, whether it's a mental capacity issue, a dementia, whether it's diabetes, whether it's heart failure, whether it's certain cancers, you can certainly leave money to those beneficiaries, those loved ones, but we have to be careful how we do it. Okay, we have to always have to have contingencies built into our plan so that the inheritance isn't going to be jeopardized. And again, I'll get into that in a little bit. If you have a beneficiary that is disabled, a child, a spouse, a grandchild, it may be just a diagnosis, or it may be an actual functional limitation. You have to be careful as to that beneficiary inheriting assets. Why? Because if they are on Medicaid or SSI, then if they inherit, then that inheritance is potentially lost, because Medicaid and SSI are both means tested programs. So if you want to leave an inheritance to a spouse or a grandchild or child that may be on Medicaid or SSI, it has to get done a certain way so that the inheritance is not lost. We've seen it happen. We've seen children inherit from parents on and the child is on Medicaid. They're getting kicked off of Medicaid. Perhaps there's a recovery issue with New York State. They've got to use their own funds. There could be penalties, and then they got to get back onto the program. So that is a real issue if a beneficiary is on Medicaid and or SSI. If you're looking at a beneficiary and inheriting, and they're not the best with the money, if they are a spendthrift, if the money just kind of flows through their hands, or even whether they're buying something or giving it away. We've had plenty of clients where the beneficiary, the child, is not the most diligent, disciplined person with their assets. And the concern is they're just going to give it away, be taken advantage of, or spend it. That is a reason for concern. And there's something that can be done when it comes to a person or a beneficiary with that type of an issue. In addition, if there is a beneficiary that you want to take care of, but there are marital issues, is it a rocky marriage? Are they in the middle of a divorce? Do you have concerns about one spouse taking advantage or overreaching? Again, You don't want an outright inheritance to that person enduring that type of an ordeal, because then that money is going to be jeopardized. All right. If you're dealing with a beneficiary that has an addiction, very real issue, impacts a tremendous amount of families, more families than they care to admit, more families than you know. And it's something that needs to be addressed in the estate plan. There are unfortunate circumstances where a person with an addiction may not spend the money appropriately, similar to spendthrift issues, but they're spending it on other types of concerns. So again, if there's an addiction out there, you want to be very careful as to how you're leaving an inheritance to that person. Also, incarceration. It does happen, of course. We've had clients with their loved ones incarcerated. If they're expected to get out, okay. If they're not going to be released, then how do we handle that type of an inheritance for that loved one? You got to be very careful as to how you do it. So again, another red flag if you're doing your estate plan. Another issue that we see quite often is estrangement. We probably talk to families once a week where something like this is going on. Haven't talked to the child or the sibling 2 years, 5 years, 20 years. There could have been a family blow up. There could have just been out of sight, out of mind, whatever it may be. If your potential beneficiary is not a part of the family anymore, either intentionally or unintentionally, it should be discussed with us so that we can plan how that inheritance is going to be received and build in some contingencies, okay? Or even disinherit them altogether, okay? The Lovelike type of scenario. I heard many years ago, and I think it's kind of true, we may love all our children, but we don't necessarily have to like them, all right? Gratefully, my children are young, I still love them, all, and I still like them all. But what you're looking at here is the reality that you may not want to leave a certain inheritance or a percentage of what you have to a certain child. Goes hand in hand with estrangement, but perhaps they're local, perhaps you see them, but they're just not the ones to inherit from you. Listen, it is not written anywhere that when you're doing an estate plan, you must leave all of your assets equally to your children. That is not written anywhere when it comes to creating your own plan. If you do not have a plan, if you do not have a will, and you do not have a trust, or you do not have beneficiaries or joint owners, then New York State will have a plan. Okay. So the idea of intestacy is when somebody passes away without a will, without a trust, without beneficiaries, without joint owners, and then New York State says, okay, a chunk goes to a surviving spouse if there is one, and then the rest goes to all the children equally. The state doesn't care if they're on poor health. They don't care if they're on Medicaid. They don't care if they have spending issues. They don't care if they're in the middle of a divorce or an addiction. The intestacy law in New York State gives everything to the children equally. All the more reason that you have to have an intelligent, thought out, written plan that covers all of those contingencies, okay? So just a little word to the wise there that you do not have to treat all of your children equally. Financial need. This could be a positive or a negative. On several occasions, just within the last year, we've had clients in here. One child is successful financially. They don't need the inheritance, but then another actually still lives with mom or dad. They have never left the nest, so to speak, and they have more of a financial need. So maybe the one without the financial need, the one that is very comfortable financially, doesn't need the inheritance or doesn't need as much of the inheritance, whereas another does. Okay, these are the issues that have to get balanced out, the issues that need to get discussed. If somebody believes that I have to leave everything to all my children equally, then the millionaire is going to get, a third of your assets. So is the one that hasn't been able to hold down a job. Same 1/3. Perhaps that's not the best scenario. Okay, different things to think through. All right. Now, when we have these types of issues and concerns, what we don't want 99% of the time is an outright inheritance. We do not want an outright distribution. As I said in the beginning, if you have a beneficiary on an insurance policy or an IRA, if you have a joint owner on your investment account or your joint account, The moment you pass, that asset is theirs. Come heck or high water. Doesn't matter if they're in the middle of a divorce or an addiction or if they don't need the money. Okay. So there are always concerns with an outright inheritance. In addition, if your will is drafted or your trust is drafted without certain contingencies or certain scenarios planned for, then the inheritance can be outright. And again, that money can land in a child's lap who could be on Medicaid. It could land in a child's lap that is going through a very difficult time financially, and they are spending every single penny they get. A proper plan, a good estate plan, is one that is thought through. Contingencies are built in just in case. Okay. So again, an outright inheritance these days doesn't happen that much. All right. Most parents and grandparents are building in different types of trusts so that their loved ones are going to be protected and the inheritance is going to be protected as well. All right. It wouldn't be the first time I've heard, you know, a person inheriting 200 grand and it's gone in a year. That was some rather unhealthy spending, unhealthy living perhaps. So inheritances just aren't about blowing the inheritance. The inheritance is also about protecting your loved one so that they don't find themselves in a circumstance with too much money too soon. All right. That is a real scenario for some families. Now, how or what can we do so that we can avoid that outright inheritance when we're dealing with all of those beneficiary issues? Okay, so there's different strategies that we can certainly utilize. Of course, there is the option of disinheritance. You can say, Johnny hasn't visited us in 10 years. He doesn't send a birthday card. He doesn't call. We haven't seen our grandkids in 10 years. He's out of the will altogether. He's out of the trust. You can do that. That's one option. That's one strategy. Okay. Another is changing percentages. So in the scenario where perhaps you have a very well-off daughter and then you have a son that has been living at home, never really took off financially or career-wise, you can change the percentages up. Okay. 5-10% to show the love, to show the intention to the one that is more financially sound, and then a greater percentage to the one that may need it because that career never took off. Okay, so different percentages can be the scenario and the solution. Then you have the option of what's called a discretionary trust. A trust is, just to give an overview of that, a trust is nothing more than a written agreement detailing the management and distribution of certain assets. Okay. And as I said in the beginning, you can have a revocable trust. That type of a trust has really one purpose, which is to avoid probate down the road when you pass away, to stay out of the court systems. You have irrevocable trusts, which also avoid probate, but an irrevocable trust is created primarily for asset protection purposes. Okay. Now, within those types of trusts, you can build a beneficiary trust, something called a discretionary trust. So for example, my parents created a trust for their 3 children. All right. I'm the middle child. I've got a younger brother and an older brother. I'll give you a scenario. If one of my brothers had an issue, a spending issue, for example, my parents in their own trust can say, we give to child 1 and child 2 their inheritance outright, meaning there's no obvious issues that they're dealing with. But with child 3, what we're going to do is have that money held in trust by a trustee for the balance of that child's life. Now, that doesn't mean there's no money. That doesn't mean there's no inheritance. What that trust will say is that the trustee, the manager, has the ability to distribute assets, what's called principal, what's inside the trust, as well as perhaps income to the beneficiary under certain circumstances. The typical 4 circumstances where a discretionary a trustee can have the discretion to pay money out would be for health needs, educational needs, what's called maintenance, and finally, what's called support. Health, education, maintenance, and support. Those are that's the typical standard wherein a beneficiary can say, I have a doctor bill, I have a tuition bill, I have a car payment, I have a mortgage payment, there's a wedding coming up. and the fiance is a solid person and the trustee wants that wedding to happen. There's a business venture that is rock solid. Those are the maintenance and support issues where discretionary distributions can occur. Now, a discretionary trust can be for a period of years. It can be for 10 years to say, when mom and dad pass, that trust will exist for the next 10 years, just so there's a little guidance for that beneficiary and they don't get it all at once. So there's a gatekeeper, okay? Or it can be for lifetime, all right? And then what happens is you just spend the money for health needs, education needs, maintenance needs, and support needs for the balance of that beneficiary's lifetime, okay? So a discretionary trust is very valuable and appropriate in certain circumstances. The next strategy that we use quite frequently is what's called a supplemental needs trust. Now, a supplemental needs trust is a safe harbor when it comes to Medicaid, okay? If a beneficiary is on Medicaid, either the welfare-based program or the long-term care-based program, then that inheritance should not be distributed outright to that beneficiary at all. It should be distributed, diverted into a supplemental needs trust, okay? Now, a supplemental needs trust, this is the premise. The government believes, true or not, the government believes that they cover all the basic life needs, perhaps with SSI as far as a payment for food, for rent, for clothes, as well as Medicaid, which covers health insurance. So if somebody's on Medicaid or SSI, if they inherit other money outright, because that is a means tested program, they look at the assets of the beneficiary, they will literally get kicked off of Medicaid and SSI. However, if the inheritance goes separately into a supplemental needs trust for their benefit, what I should say is a forced supplemental needs trust, the will says, I give a third to Johnny, but in this supplemental needs trust for the balance of their life. It's a forced distribution into this supplemental needs trust. And that supplemental needs trust is there, like the title says, to pay for what's considered to be supplemental needs. Again, the government thinks they cover the basics, food and shelter, for example, insurance. But the supplemental needs trust is there for the handicap accessible van. The supplemental needs trust is there for the cell phone, for the trip to Disney. It's there for everything the government doesn't pay for. That is how you plan for a beneficiary with special needs. That is how you plan perhaps for a spouse that's on Medicaid. So a very real scenario in our law practice is when we're doing Medicaid planning for Mr. Smith. If Mr. Smith now needs Medicaid, the wife, Mrs. Smith, needs to change her will. For example, if Mr. Smith is now on Medicaid benefits at home or Medicaid benefits in a nursing home, how much do you want to bet their 40-year-old last will and testament is what they call an I love you will? So Mrs. Smith's will is certainly going to say, I give everything to my husband. That's how the wills are typically written when folks are younger and healthier. But if one spouse is on Medicaid, 100% that will needs to get updated to either disinherit the Medicaid spouse, okay, or to have a portion of the inheritance go into a supplemental needs trust, okay, to cover, again, supplemental needs, everything that Medicaid doesn't pay for. Entirely part of a comprehensive strategy. Again, if you're looking at one spouse with Medicaid, there is the idea, the concept of a right of election, meaning, and this is where, not the purpose of today's webinar, but if Mrs. Smith leaves everything to the 3 kids and disinherits her husband, and then Mrs. Smith passes away first, which does in fact happen, then we have right of election issues, which again is a topic for another webinar. But it's all a part of the plan. It's all a part of looking forward and saying, this is a possibility, this is a possibility, how do we plan for it, okay? So again, there are certainly complications and risks when you're talking about Medicaid and you're talking about inheritances and different spouses passing away. But the best way to cover most of the bases is with a supplemental needs trust for anybody on Medicaid, all right, or again, disinheritance, all right? If you have questions on that, please feel free to put it in the Q&A box. Now, another strategy that we often use, actually we use it every single day, is what we call a contingent supplemental needs trust. And SNT stands for supplemental needs trust. So that's where we have the potential for somebody being disabled in the future, or ill, or on Medicaid, or on SSA in the future. And that is a potential reality for every single person, including myself. So when we're dealing with a will or a trust for a client, we always build in a contingent supplemental needs trust just in case that beneficiary is on Medicaid. So for example, if Mrs. Smith prepares that last will and testament or that trust for her 3 children as beneficiaries, there will be a contingent S&T built in there. If God forbid one of those children suffers an accident or some type of an illness and they're on Medicaid, or dementia concerns and they're on Medicaid, then when that inheritance goes to that person, it will be diverted because the contingency of being disabled has been met. Therefore, this supplemental needs trust will pop up and capture the inheritance and protect it and preserve the government benefits. Okay. So quite honestly, every single attorney that does estate planning and elder care work for a living will build this type of trust into their plan. If you're dealing with an attorney that does not specialize in estate planning, that does not specialize in elder care and elder law, then you need to find an attorney that does, because we focus on risks and we focus on contingencies, okay? Now, finally, the last strategy to use is a contingent minors trust. And again, this should be in every single will, every single trust that you have, and that's prepared by your experienced attorney. We include this in everything. So just like when I was talking about beneficiary issues, I said somebody under 25, when we see an existing client's will, a new client's existing will, they might have a trust for minors built in there that says, if anybody's under 18, that money gets held by my trustee until they're 18 or until they're 21. I don't like those ages. I think they're too young, especially in this day and age. So we're always going to recommend that trust for minors be adapted and changed until they're older. And this trust for minors is a discretionary trust. So the money would get paid out for health needs, education needs, maintenance needs, and support needs. Okay, so they always have the money if it's needed and demonstrated to the trustee, but they just don't have full access until they hit whatever age you pick. Okay, again, a necessity, and any experienced attorney is going to be including it. Okay, in fact, most inexperienced planning attorneys also include it just because they see it done. But it's part of a very comprehensive plan. All right. So knowing that these are our strategies, and that if it comes time to disinherit, let's talk about those issues again. So again, let's go through them one by one pretty quick. If we have somebody that is if we have a beneficiary that's under 25 years of age, again, you build a mandatory forced discretionary trust, or you do the contingent trust for minors, again, discretionary. If you have a loved one or a beneficiary that's over 65 and they're healthy, make sure you have a built-in contingent supplemental needs trust. If you're leaving assets to a beneficiary that is in poor health, you can go to a forced SNT or a contingent SNT, depending on age and health and the overall scenario. If you have a loved one that's disabled, 100%, it's going to be a forced distribution into a supplemental needs trust. If you have a beneficiary on Medicaid or SSI, you have, again, a forced distribution to an SNT. If they're not on Medicaid when you draft your plan, as long as you have the contingent SNT built in there, then that's a good thing. Now, a word to the wise. If you have a beneficiary, a child that's disabled, do not disinherit them automatically. We sit with clients. It hasn't happened much lately, but when I've been doing this for 23 years, and years ago, folks would come in, I've got a child with this diagnosis, I'm going to disinherit them. Don't do that. You don't have to do that. You want an inheritance, protected inheritance for a disabled beneficiary. Government programs are being cut more and more every year. Group housing is generally declining year after year. Okay, so there may be a need for a pot of money for that disabled beneficiary. So do not automatically just disinherit them, but rather deal with an issue where, or deal with the supplemental needs trust that can preserve an inheritance and keep the benefits. Okay, If you have a child with spendthrift issues, you can disinherit, you can change the percentages, or you can use a discretionary trust. Again, health, education, maintenance, and support. Marriage issues. Again, I wouldn't necessarily disinherit, but you can do that discretionary trust so that you can build a wall between the inheritance and a divorcing spouse. All right. Addictions. Again, you're looking at a potential disinheritance or creating a discretionary trust, which raises another issue with addiction issues. And I'll talk about that, I think, on the next slide. But again, you don't necessarily have to disinherit. You can change up the percentages. Incarceration, definitely a certain type of trust has to be put into place. If there is a victim out there, there are restitution issues. You do not want an outright inheritance at all for somebody that's incarcerated. If you have a child that is estranged, again, you're looking at disinheritance or changing percentages. Most folks I sit with really look at disinheritance, all right? No soup for them because they haven't been involved, they haven't been a part of the family, bad things have happened, and it's a time for the family to say, that person does not inherit, does not deserve, does not earn that type of family wealth. The Lovelike principle, okay? Again, disinheritance or change a percentage, or just be mindful of the inheritance with a discretionary trust. And finally, financial need. If you have that child that is perhaps that wealthy physician or wealthy by other means, then talk to them and say, maybe, you know what, is it okay that you don't inherit? This is what I'm thinking, that you don't need it so much, but your sister does, your brother does. Have that conversation when it comes to financial need, okay? So there are definitely circumstances where you need to disinherit your spouse, disinherit a child, but there's also circumstances in which you can just tailor and modify the inheritance to protect it, okay? Now, be prepared. There can be fallout when you make these tough decisions. There can be emotional risks, there can be resentments, there can be turmoil, there can be tension and stress on the relationships. That does not mean that you do not establish a plan like this. It just means you need to be aware of it. The reality is, if you're convicted and feel strong enough to modify their inheritance, then please also be prepared for this, okay? Now, these are certainly tough decisions. So the first question is modifying the inheritance in trust, or is disinheritance the right thing to do? Is that inheritance going to be lost to Medicaid? Is that inheritance going to be spent at the mall, or are they going to buy a Corvette when they don't need a Corvette? Is that inheritance going to be used inappropriately with different addiction issues? Is that inheritance going to a child that hasn't talked to you in 20 years? Is it the right thing to do? That's a discussion that you need to have with yourself, with your spouse, perhaps, your other kids, if that's appropriate, as well as myself or your attorney, okay? Trustee selection, another tough decision. Often we're setting up these types of trusts so that, again, Mrs. Smith with the 3 kids, if one child has an addiction or a spendthrift issue, who are they going to name as the trustee to manage that money, to manage those distributions? It's not going to be the child with the issue, right? It's going to be the older brother or the younger brother. That can present conflict, that can present really unwanted circumstances, that can cause 3 a.m. phone calls, that can cause somebody pounding on the door at 2 a.m. So these are, who you pick as a trustee really is dependent on the needs of the beneficiary. There are accountants that serve as trustees. There are attorneys that serve as trustees. If there is a significant sum of money and you do need an institutional trustee, then that is appropriate. Generally speaking, if you're dealing with addiction issues or other needs-based issues, an institutional trustee can be the best answer because they're going to have a phone number. They're not going to have a house to go knock on. And therefore, you can let the relationship between the siblings try to restore itself or be maintained, okay? You don't want, by doing this, you don't necessarily want to cause more issues with the children. So you have to do it prudently and with the right advice. The idea of a family meeting. Is that appropriate? Is that necessary? Meaning, is it good? Should you talk to the child before you disinherit them? Should you talk to them before you change and modify how they inherit? That, again, is a family decision. I've had clients certainly say, I'm telling them this is what's happening. coming from the horse's mouth, forgive me, but coming from the horse's mouth, coming from the matriarch or the patriarch can sometimes settle the issue. If that's not possible or not desired, then you don't talk about it, all right? When we do planning for folks, we offer family meetings where these types of issues can be discussed. Again, big, heavy disinheritance issues should be handled before you come to the lawyer's office as a family. But again, having a family meeting, talking to the person that this applies to is certainly an option, and sometimes it's a good thing to do. All right. Now, how do we do this? When we sit with families, we focus on 4 different services, 4 different types of plans. The first one is what we call a probate plan. That's going to be a basic, simple estate plan. It's going to be your last will and testament that I've been talking about. That's what requires probate. It's going to be a durable, modified power of attorney, probably the most important document there is to pick somebody to handle your financial and legal affairs. It's going to be healthcare documents, the healthcare proxy, and the living will. So in this type of a basic estate plan, your assets that are in your name solely will go through your will. Those that are jointly owned go to the joint beneficiary. Those that have beneficiaries go again to that beneficiary. A basic plan, generally for younger, healthier folks. Then we prepare what's called a probate avoidance plan. It's going to be all those basic documents, the will, the power of attorney, the healthcare proxy, and the living will, but it's also going to include the probate avoidance tool, which is the revocable living trust, okay? So if we have a spousal circumstance, both the wife and the husband, the spouses, would have their own individual revocable trust that can own certain assets, that can contain subtrusts for beneficiaries, disabled, spendthrifts, et cetera, all built into that revocable trust, and the will as well, if appropriate. But again, that avoids probate so that the beneficiaries inherit faster, less stress, less fees, less costs. Then we prepare for certain folks what's called an elder care protection plan. The elder care protection plan, again, is going to be the basic estate plan, okay? It's going to be the will, the power of attorney, the healthcare proxy, the living will, but it's going to be the irrevocable trust. For this plan, this is appropriate for those that are 65 years of age and older. And if you're out there listening to this at that age and you haven't planned and protected for the potential of long-term care down the road, then this is the plan for you to implement as soon as possible because of the idea of look-back periods and waiting periods, okay? Again, we focus on those that are 65 years of age and older. No care needs yet, okay? This is older, healthier folks. Then finally, our signature service is what we call a life care plan. This is going to include an estate plan that we've been talking about. It's going to cover asset protection and income protection, as well as Medicaid benefits for home care or nursing home care. It's going to include care coordination and advocacy. What we do very differently than my colleagues here on the island in New York is we have a life care plan service, which is an all-inclusive, hands-on service where the attorneys and our geriatric social workers, our advocates, will come on board to help the family as the loved one continues down the elder care continuum, as they age and endure these care issues. Very comprehensive plan that covers everything. We have dozens and dozens of families that are life care clients because their loved one has care needs. And this is going to be the most comprehensive service to help the entire family down that road, okay? So what we've talked about today, and I've been going pretty fast because we're over, is the idea of disinheriting or at least modifying an inheritance for somebody that you love that will be inheriting from you. Now, there's different ways to do it, different estate plans, probate plans, different trusts, revocable trusts, irrevocable trusts that allow you to do that. If you have any questions, I'm always available. You can email me directly, Brian, B-R-I-A-N, at tullyelderlaw.com, T-U-L-L-Y. Or for those that are on the phone, not watching, the phone number is 631-424-2800. Again, 424-2800. You can find us on Facebook. Believe it or not, you can find us on Instagram. Now, we have a bunch of questions. Let me see what's going on with those. So, first question. Disabled individual received inheritance. He's on Medicaid. What should I do? So, talking about it, a beneficiary that is disabled receiving an inheritance. That inheritance, as we covered, should 100%, and you asked this, Mike, before we got to that, but it should certainly be diverted into a supplemental needs trust, okay? Again, if you did the plan with somebody that knows what they're doing, that type of trust will be directed for the inheritance, or it will be a contingency and it'll pop up if that need is there. Next question, does a supplemental needs trust need to be set up prior to going on Medicaid benefits? Well, I'm going to say yes, because the idea of planning in advance and having the plan in place is appropriate. But if you're dealing with a spousal situation and one spouse is going on Medicaid, during that process is when the quote unquote well spouse will update their will and their trust so that the other spouse either doesn't inherit or does inherit a little bit through the supplemental needs trust. Supplemental needs trust, are there limits as to what can be purchased for the recipient with an SNT? And the answer is yes. You're not allowed to use the assets within a supplemental needs trust to pay for anything that the government is paying for, okay? So the purpose of a supplemental needs trust is to buy supplement needs, not supplant, not replace any of the government benefits. So yes, there are definitely limits as to what can be purchased. Another question, after death, which choices require ongoing professional supervision, and which are the, I guess, the faster conclusions? Well, an outright inheritance after somebody passes away will require either an estate administration or probate proceeding, or a trust administration. The trust administration is usually 99% of the time faster, and it's about winding down the parent's trust who's deceased and creating the new trust to hold the inheritance for the beneficiary. You're still looking at a couple of months before that's all finalized. I would not judge and not make a determination on an inheritance by how fast the beneficiary inherits necessarily, meaning outright is faster, so do that. Because if that outright inheritance, as I've been sharing for the last 45 minutes, is going through a rough marriage, has spendthrift issues, is on Medicaid, is disabled, has poor health, then it's worth the time to have that second sub-trust established for them. All right, so hopefully that answers your question. Would it be better to leave assets to a relative of the Medicaid recipient? Okay, interesting question. So if you have a beneficiary on Medicaid, you have different things to do. You can disinherit them altogether, which I don't prefer. You can leave assets, the inheritance, to a sibling to hold for their benefit, or you can leave it in a supplemental needs trust for them. The question is it good to leave it to a sibling? The reason I don't like, for example, go back to our 3 kids. If we go back to the 3 kids, wait, I lost my question here. There we go. If we go back to the scenario of 3 children, if you decide to disinherit the disabled Medicaid recipient middle child and leave his third to the older child, there are definitely risks. If that older child becomes disabled himself, there goes that money. If that older child gets divorced, if that older child predeceases, where does that money go? When you have the assets held in a trust for the disabled child's benefit, then 100% that is the better way to go, because no matter what happens to the siblings, that fund of money for your disabled child won't be impacted, okay? Am I going the right way? I'm not going the right way here. Forgive me. I think somebody asked a duplicate question. That's what threw me off, and people are adding questions. Can an SSI monthly payment, can rent payments? So it depends if the person's on SSI themselves. The SSI is meant to cover rent. If they're not on SSI, you can have a beneficiary on Medicaid and not SSI. And in that case, yes, you can have the supplemental needs trust cover the rent. Is there a way to talk to clients about transferring their assets into a lifetime trust? It's not about persuasion. It's about kind of laying out the facts. The idea of a lifetime trust, either revocable or irrevocable, will certainly save time. It will save money. It will protect assets. It can protect income. It can keep privacy. It can have children inherit and spouses inherit faster than going through the court process of probate. So laying out the pros and cons of establishing a trust during life is typically the best way for that light bulb to go off. Wife has long-term care insurance and husband was denied long-term care insurance as a policy. So only that one spouse has it. Does this affect trust planning? It doesn't affect it, what you want to do is still put into place the elder care protection plan. You need that irrevocable trust, because just playing out the scenarios, if the spouse without the long-term care insurance needs long-term care, we might have to go Medicaid. So in that case, we could go the spousal refusal option, which is give everything to the spouse that has the insurance, the well spouse, and then apply for Medicaid. Or if we've protected our assets in advance, then we can actually have the assets in the irrevocable trust for both spouses. The reason I like that plan better is, even though somebody has long-term care insurance, at least 60–70% of the time, that long-term care policy is not going to pay for the whole long-term care need. It could be $100 a day of home care coverage when the cost is $300 a day. It could be $200 a day for nursing home costs when the actual facility is $600 a day. So typically Medicaid is still needed. So I do not like the spousal refusal option. I like the plan in advance option, so you get the protection done. What happens to money in an S&T after the individual dies? So good question. Without getting too technical, there's two types of supplemental needs trusts. If you are putting the supplemental needs trust in your own trust for the benefit of your child, for example, that is what's called a third-party supplemental needs trust, and you determine where that money goes after the disabled beneficiary passes away. So again, Mrs. Smith has 3 kids. The assets, the inheritance for the middle child goes into a supplemental needs trust. It's your money, not the disabled child's money. So therefore, you say after that disabled child passes, that 1/3 goes to the 2 siblings. The alternative is where there's no supplemental needs trust in place, that middle child who's disabled is getting this inheritance. The courts, the law, will allow us to establish what's called a first-party supplemental needs trust, kind of a quid pro quo, and they say, we'll let that person keep Medicaid, but when they pass away, then the state gets paid back, okay? So the answer to your question is it depends what type of trust. Wow, we got more questions going on here. All right, I have a couple more minutes. If an elderly person sets up an irrevocable trust, what is the current look-back period before Medicaid eligibility? That is a trick question if I've ever heard one these days. Black and white answer is a nursing home will always have a nursing home Medicaid will always have a 5-year look-back period. That's what we've had for all types of asset protection steps for decades. Home care, on the other hand, is going through a tremendous change as we speak. I've done several webinars on this. Again, if you go to our website, tullyelderlaw.com, under videos and under webinars, New York State signed into law, effect last year, a law implementing a look-back period and therefore penalties, just like a nursing home, for home care. The saving grace here is it hasn't been implemented yet. They keep postponing it. However, the current law is that any home care applications filed after April 1st, 5 weeks away, will in fact have a look-back period. And if any assets were protected during that look-back period, if they file before April, they will be fined because there's no look-back. But if they file after April, then they will get hit with the look-back. There is rumors, there is talk from the Department of Health that they may postpone that to July 1st. It has to do with the fact that the country is still undergoing the pandemic. So bottom line is there is a nursing home look-back period of 5 years, which is the primary reason why we always like folks over 65 to get that elder care protection in place sooner rather than later, okay? And then home care, real gray area now, but it will have a look-back period eventually. Do 529 accounts, are 529 accounts affected by Medicaid? The answer is yes, they count as assets of the applicant. If a beneficiary is disabled and receiving Medicaid, then passes away, what happens to her inheritance? So similar to before, if there is a supplemental needs trust in place and the supplemental needs trust holds assets from the parent, then that is a third-party supplemental needs trust. And after the beneficiary, the disabled beneficiary passes on, then that can go to other people that the parent already selected. Do we work with clients outside of New York? I am, and my attorneys are admitted in New York State. One of my associates is admitted in Connecticut, but we are 99.9% a New York-based firm. We deal with New York Medicaid, New York trusts every single day of the year. If you're looking at Jersey, Pennsylvania, Florida, other states, I've got good, solid connections in other states, and we've worked with all of them pretty successfully. All right. All right, answer that question. Would it be better to leave? Okay, I did that one. I'm scrolling back up. I think I've answered everything, folks. Dun, dun, dun. All right, I think I've answered everything. So I want to say thank you for joining us again. We'll be back in 2 weeks. It is March. It's St. Patrick's Day is coming up. We'll be talking about protecting your pot of gold. So please look out for that email, and you can register and learn about asset protection and keeping it from those greedy little leprechauns. All right. Thank you again, folks. If there's anything we can do for you, please feel free to reach out, and we'll do all we can. Thank you. Here we go.